Hello, everyone. Welcome to the Post-Roe Nashville Forum. We have a lot to cover today, and I'm really happy to have such a great panel and that Mayor John Cooper has taken the leadership to help convene us today. I'm going to introduce the mayor to you. Before we get started, I want to start with the end in mind and let you know that there's so many things that you can do to plug in. And so if you want to go to tnadvocatesforpp.org and sign up for our emails, we can loop you into some of that work. But I want to begin first with the person who helped make all of this happen. Thank you to Mayor Cooper. He's going to come up and say a few words and kick us off. Thank you.
Thank you all for being here, and kick everything off, I want to thank Councilman Nash for being here, and then my partner and everything, Deputy Mayor Brenda Haywood. And I want to start, thank you, Francie, for saying something I don't think that I've ever said before to begin an event, which is I wish we did not have to be here today. And like so many across Nashville and the country, I was saddened when the Supreme Court overturned 50 years of precedent and took away a fundamental right for millions of people across the country, including hundreds of thousands of people right here in Nashville. Now, having access to reproductive health is a fundamental human right, and it's a shame that we even have to say that. And we do live in a state where that right is no longer protected. However, Nashville is a welcoming city, and we strive to be a place where everyone, no matter your zip code, race, religion, sexual orientation, income, or belief, can live and thrive. Inclusion is our strength, and that's why people all over the world move to Nashville, in part. We're a city of opportunity, and we're a city of inclusion. So at the moment, it looks like we cannot prevent the state's restrictions from going into effect. We will do what we can to protect a woman's right to choose and to keep residents informed. Now, a few weeks ago, I proposed legislation that would reimburse any of the nearly 20,000 Metro employees for travel costs related to receiving medical care unavailable to them in Tennessee. And the resolution was sponsored by Council members Berkeley Allen, Delisha Porterfield, Aaron Evans, and others, and was overwhelmingly adopted by the full council. And we're doing what we can for employees, but it's also our job as a Metro government to keep our citizens informed about the law so that everyone can receive the resources they need to take care of themselves and their families. So that's what we're doing. And that's why I'm honored we could join Planned Parenthood of Middle Tennessee in co-hosting this forum tonight. I hope all of you here and the folks who are watching at home will leave with a better understanding of what's legal and what's not, and how you can continue to access the health care that you need. Now, before I wrap up, I do want to specifically thank Francie Hunt from Planned Parenthood. Francie, thank you for partnering with us in this event tonight, but more importantly, thank you for the tireless and invaluable work that you and your organization do every single day in an increasingly difficult environment for folks across the state. And please, if you would join me in acknowledging and thanking Planned Parenthood. Thank you very much. Yes. And Frankie will do the more formal introduction of our panelists shortly, but I'm grateful to this incredibly impressive and distinguished group for participating tonight. Could we have a better panel, more informed panel? I don't think so. So Dr. Clayton and Dr. Looney and Dr. Thompson and Bill Harbison, and of course, Metro's own legal director, Wally Deeds. Thank you again for all being here, and I'm gonna let me turn this program over to Francie and on to the important voices to educate and inform on this subject tonight. Thank you.
Thank you so much. And I have to give credit to Mayor Cooper for taking the leadership. He's made Nashville a great example to what local municipalities can be doing all across the state, inspiring places like Memphis and soon to be Knoxville to be doing what we can at the local level to protect our people. We know that with the fall of Roe on June the 24th, that meant at that moment that we were going to see, not only in Tennessee, but the entire southeast region of the United States, people having to flee the state for care or being forced to give birth. And so it brings up real issues for us to consider. It raises a lot of questions that we have, and hopefully tonight we'll be able to address a lot of the questions. And I thank you all for registering and sharing some of your questions. They've been shared with the panelists, so hopefully a lot of the questions that you have will be met within their presentations. So the first segment of tonight's program will be addressing some of the legal aspects. And so to introduce formally some of our panelists, I want to mention that we have Wally Dietz, who's the Metropolitan Government Law Director. Mr. Dietz has over 35 years of experience as a practicing attorney, and prior to his appointment as the law director by Mayor Cooper, he served as chair of the Compliance and Government Investigations Group at Bassberry and Sims in their Nashville and Washington, D.C. offices. In 2002, the Nashville Bar Association awarded him the Liberty Bell Award in recognition of his pro bono work in international human rights. So we're really grateful to have him lend his expertise today. Joined also by Bill Harbison, who's a partner at Sherrard Rowe, Voigt and Harbison. Mr. Harbison has 42 years as a practicing attorney and works primarily in the areas of corporate law and trusts and estates. In 2015, Harbison was one of the lawyers in the Obergefell and Hodges case who argued successfully that same-sex marriage is a constitutional right. And also followed is kind of our, she shares both worlds of legal and medicine. We have Dr. Ellen Clayton, who is a law professor and a pediatrician, who for decades has been a passionate defender of the rights of individuals to make their own reproductive choices. She has served on the board of Planned Parenthood, and she's led national studies about access to contraception and taught and written numerous articles about reproductive rights. So she'll be our final kind of legal perspective, and I'll pause there and then introduce our physicians who will be speaking about the medical implications of the law. So I'm going to turn it over to Wally Dietz.
Thank you, Francie. First, I'd like to thank Mayor John Cooper and Planned Parenthood for sponsoring this event. Obviously, it's a topic of concern for many people, and I'm glad to see so many people here tonight. I'm going to talk about the state of the law, where we are in Tennessee now. And I've received some of the questions that were submitted online. I'm going to try to address those in my comments, but we will have time at the end of the program after all panelists have spoken to take additional questions from the floor. Let me first start very quickly with the timeline. You know a lot of this already, but just as a refresher, 1973, Roe v. Wade establishes a constitutional right to an abortion. 1973 forward, some states started putting limits or regulations around abortion, such as informed consent and other things, but the fundamental right remained in place. In the year 2000, the Tennessee Supreme Court, in a 4-1 decision, one partly concurring, mainly dissenting, recognized under the Tennessee Constitution's provisions that established a right to privacy. The Supreme Court acknowledged and established a constitutional right to an abortion in Tennessee under the state constitution. But as many of you know, those in the country who are opposed to abortion have organized regularly to try to chip away and to undermine the right and eventually to overturn Roe. So as a part of that, in some states where the courts had said under the state constitution there's a constitutional right, people who were against abortion put referendum on the ballot or constitutional amendments to take away that right. And that's what happened here in Tennessee. And many of you will remember in the year 2014, a constitutional amendment was passed by 53% of the voters that said Nothing in this Constitution secures or protects a right to abortion or requires the funding of an abortion. The amendment specifically said that the people have the right to regulate abortion through their elected officials. In a few minutes, Bill Harbison will discuss some of the litigation and politicking that went around that amendment. So that brings us to 2022 and the Dobbs decision, and we all know what that did. Roe is overturned. It is no longer the law of the land as a matter of a federal constitutional right. It was a 6-3 decision, but many people do not focus on the fact that there were only 5 votes to overturn Roe, not 6. Chief Justice Roberts said he would not have overturned Roe. He believed in affirming the precedent that Roe established that for a, quote, reasonable, quote, amount of time, a person should have the right to get an abortion. He would have affirmed the Mississippi statute, but he would not have overturned Roe. So just as a historical footnote, if Merrick Garland had been confirmed to the Supreme Court, Roe would likely be the law of the land still today. The decision in the Dobbs case has extensive repercussions. Roe was based on a line of cases that started in 1965, a case called Griswold versus Connecticut, that said in a 7-2 opinion that based on various rights in the Constitution, people in the United States had a right to privacy. And the right to obtain contraception was covered by that right to privacy. So starting in 1965, there was a line of cases based on privacy rights that protected individual liberties. It is clear that a majority of the U.S. Supreme Court is now ridiculing that line of analysis, saying it simply is fiction, legal fiction. And that has consequences in various parts of our life, but specifically in the world of reproductive health. If you use that analysis, you can say there is no constitutional right to contraception. And that means that a state could ban contraception. And that gets into very complicated questions of what is contraception. And I'm going to talk about some specific medical devices and procedures as a matter of law, but we have our medical experts who will address the medical side of it. So that's where we are. What is the state of the law in Tennessee today? So there's no constitutional right to an abortion as a matter of the federal or the Tennessee Constitution. For 2 weeks now, until August 25th, we're under what's called the heartbeat law or the 6-week law. I'm not going to talk about that because it will be superseded in 2 weeks by the Trigger Act, which was passed by the legislature that said if Roe is overturned, then we are criminalizing abortions in Tennessee. And so that law had a 30-day trigger. Once certain legal proceedings happened after the opinion was published, and the trigger law goes into effect 2 weeks from today on August 25th. So that's what I'm going to focus on. The Trigger Act bans the performance of an abortion after fertilization. It's the earliest possible part of the sequence where abortion could be established. The act says that, quote, a person who performs or attempts to perform an abortion commits the crime of criminal abortion. Criminal abortion is a Class C felony. Under Tennessee law, Class C felony has a prison term of 3 to 15 years and a fine of up to $10,000. Under the Trigger Act, the patient is not subject to criminal prosecution. Only the providers and the people who assist the provider in performing the abortion. There are anti-abortion laws all over the United States. Tennessee is one of the few states that does not recognize an exception for the life of the patient. So in Tennessee, there is no exception, automatic carve-out for the life of the patient. There is instead a criminal defense that a healthcare provider can utilize at a criminal trial, after they have been indicted, prosecuted for the act of criminal abortion, and they can establish a defense to the crime if they can prove essentially they are a licensed provider. The abortion was necessary to prevent the death of, I'm reading the statute now, to prevent the death of a pregnant woman or to prevent serious risk of substantial and irreversible impairment of a major bodily function. Mental health cannot be used to justify an abortion. These terms are not defined. As a lawyer, it's maddening that there's no definition for this, but I'm sure for the medical experts on this panel, it's even more disturbing that this statute has so many gray areas that we are in a very dangerous territory in Tennessee once we get to August 25th. So think about this. A medical provider faced with a very sick patient who has an urgent medical condition has to weigh the risk of providing medically necessary care against the risk of being prosecuted for a crime that could put them in jail for 3 to 15 years. That is the reality of where we are in Tennessee today. It's interesting. Interesting is not the right word. To me, it's concerning that there are some people who believe that IUDs are, that's an abortion because they just believe that by anything that disrupts post-fertilization is an abortion. So an IUD in certain circumstances can be considered an abortion. So can medical providers in Tennessee prescribe an IUD without fear of being criminally prosecuted? I mean, that's a very open question in Tennessee right now. I will say that to the extent you're following any of this on social media, watch out for the case in Idaho, because Idaho is one of the few states that passed a law as restrictive as Tennessee's. And the Department of Justice filed suit on August 2nd saying that the Idaho statute violates various federal laws about the provision of emergency medical treatment. So follow that case and see. If the courts decide that the Idaho law can be overturned because of the federal statutes, then that will have a significant impact on the court's analysis here in Tennessee. So where we are today is we have this criminal act. There are things the legislature has discussed doing that could very much come up in the next legislative session. For instance, they could criminalize interstate travel to go get an abortion. It could criminalize raising money to pay for somebody else to go to Illinois or another state to get an abortion. We'll all have to be watching carefully as the legislature considers its options. So just bullet points briefly. A person in Tennessee right now cannot order or receive abortion pills from an out-of-state pharmacy and have those mailed to Tennessee. That's a crime. A person may travel to an out-of-state pharmacy and get abortion pills, but they must complete the regime while they're in that state. If they bring some of the pills back to finish the course of treatment with the pills, and they do that in Tennessee, that's a violation of the law. A person in Tennessee cannot use telehealth to get a prescription for an abortion. An employer, as of now, whether public or private, may do what Mayor Cooper talked about, which is to have a benefit for employees to fund their expenses to travel out of state. Currently, that is permissible. We'll see what happens next year in the legislature. And to anticipate, or actually to answer one question that did come in online specifically, Metro does not have the authority to overrule state law. It's just a basic rule of civics. Federal law wins, state law wins over local ordinances. So Mayor Cooper and the Metro Council, they have no authority to do something that directly contradicts the state law. If we believe the state law had constitutional defects, we could sue. But there is, having taken away the right under the Tennessee Constitution. Don't expect somebody to sue and say it's unconstitutional, because we now have an amendment that says the legislature can do exactly what it did. I'll be glad to answer questions at the end.
Thank you so much for that. And I think, you know, one of the things to keep in mind is that what I'm hearing is that we've got somewhat of a window before the legislature convenes January 10th, I believe, and starts working on some laws that will be even more restrictive, if you can even imagine that. So now is like a really important window for us to be communicating freely with each other about what's at stake right now, letting folks know that they could go to abortionfinder.org and get information about where they could obtain an abortion or schedule an abortion as needed. So I'm going to turn it over to Bill Harbison, because obviously abortion is the just one piece of this Jenga puzzle that just got pulled out when Roe was undermined, and it affects all kinds of things. So please speak to that.
Well, thank you so much. And Wally, thank you. That was a really thorough presentation of where things are today in Tennessee. I'm here tonight because I was involved in, I guess, two cases that I'll briefly talk about that I think shed some light on where we are and maybe things that might be coming up in the future. The first case that I had some involvement with, along with lots of other lawyers and clients, was the Obergefell case. And this is a case about, we called it marriage equality, about same-sex marriage. And that case, we filed that in Tennessee in 2013. Our clients were same-sex couples who had moved to Tennessee from other states, were legally married in other states, but we had on our books in Tennessee both a statute that defined marriage more narrowly as only one man and one woman, and we also had an amendment to our state constitution, as we do here in the reproductive rights area, that limited marriage to one man and one woman. So as it stood in Tennessee in 2013, states were free to prohibit the recognition of same-sex marriage or to permit two people to become married in our state if they were of the same sex. The court was evolving, the jurisprudence in this area was evolving, and we were hopeful that we could bring uniformity to the country by having a case that would establish these rights throughout the country. But in 2013, as we are here now today after the Dobbs case with reproductive rights, the laws among the states were a patchwork. Some states permitted same-sex marriage. Other states prohibited same-sex marriage. The effort in our case was to bring uniformity to the country so that when people traveled across the country from one state to another, their marriages didn't cycle on and off in terms of what the law believed about their marriage, and that they might be legally married in New York, but when they moved to Tennessee, they were not married, and with all of the rights and responsibilities that go with that. The case progressed and was decided in 2015 by the United States Supreme Court, along with cases from Michigan, Kentucky, and Ohio. So Tennessee is part of the Sixth Circuit, which is an appellate circuit in the appellate system of the country. And we lost the case originally in the Sixth Circuit. The Sixth Circuit 2-1 ruled that states could fail to recognize marriage equality, that it was fine for states to experiment about different ways of treating marriage throughout the country, and that was a permissible exercise of state autonomy. And it was really, they based their decision on some notion of federalism, that we should let the states experiment with what they want to do. In 2015, and I think the significance for today is that when the case did get appealed to the Supreme Court, they took the case, and in a 5-4 decision, they held that no, states can't restrict the rights of people to marriage, that it does need to be a uniform standard, and that's based on the Due Process Clause of the Constitution and the Equal Protection Clause of the Constitution. The same bases, really, that undergirded the Roe versus Wade decision, the Griswold decision, And the arc of Supreme Court jurisprudence up until 2015, I think really could fairly be said to have been to expand individual rights, not to narrow them, but to expand them significantly. It was a big day. The White House put in 2015, the White House put a rainbow flag of lights on the White House. There were people who were unhappy with the decision, but I think the vast majority of the country today is comfortable with that decision. They weren't maybe back in 2013, but today they are. And again, I just mentioned that because now Justice Thomas, in an opinion in the Dobbs case, has said, the court ought to revisit the Obergefell decision. It's now 7 years old. The sky hasn't fallen, the country's still operating smoothly, and yet there's now a Supreme Court justice, at least one and maybe more, who are wanting to revisit that decision. So, and overturn it. So one of the things that I think is troublesome about where we are now is that in the Dobbs case, the court, as I think Mayor Cooper has said, changed 50 years of Supreme Court precedent to narrow individual rights. The principle of stare decisis, which is to respect already decided cases, is at least in question, and so individual rights are at least in question. That could, I think, as Wally has mentioned, the reasoning in the Dobbs case, the court did put in a statement that this is special because it's abortion, and we're not saying for sure that we're intending to abrogate other rights, but the reasoning is based on this notion that if a right is not deeply rooted in American tradition, it's not necessarily a right that's protected or should be protected under the Constitution. And the court says, well, the word abortion doesn't appear in the Constitution. Neither does the same-sex marriage, neither does contraception, neither do lots of things that we count on as individual rights get mentioned explicitly in the Constitution. It's not that kind of document. But that's all to say that this is probably not a time when, at least on the big issues, we can successfully think about filing another case and changing the court's mind. In fact, if anything, there's worry that it could go further in a different direction. So strategic litigation, which is what I've been engaged in some cases, that's probably not where we are. I think we're in a landscape of needing to change people's minds, to lobby at the ballot box. That's the kind of landscape we're in right now. The second case I'll just briefly mention is a case that was about what Wally has already mentioned, and that is when Tennessee adopted a constitutional amendment that took away the state constitutional right to reproductive choice. That happened in a fairly close vote, and the vote was calculated under our state constitution, and I don't want to get in the weeds too much, but in a very suspect way. One of our challengers to that law was Dr. Clayton, who's right here. She was, I'm proud to say, one of my clients in that case. We challenged the validity of the voting on that amendment and actually won the case at the district court level, and sadly for us, it was reversed at the Sixth Circuit, and the Supreme Court did not grant review of that case. So that permitted the constitutional amendment to go into effect and change the law to take away the constitutional right that had been granted by our state Supreme Court in 2000. I guess all of this is just to say, and I'll end with this, but I'm happy to answer other questions, but is to say that I'm not sure that now is a time when we can do a lot with litigation. We might be able to do something about the right to travel. That's a deeply rooted right in our Constitution also, the right to travel from state to state. We don't have to get passports to go to Kentucky. It's a right that we have all taken for granted. It's been recognized by the Supreme Court of the United States. In fact, one of the leading cases is right here from Tennessee from 1972 called Dunn versus Blumstein. So we have the right to travel, but I think the scary thing that might be happening now is that even that right in this context of reproductive rights may get called into question, and perhaps there'll be cases about that. But with that, Francie, thank you. I'm going to stop there, but happy to answer questions.
That's great. Thank you so much. And I think the important thing to remember, especially as we kind of consider the politicization of the Supreme Court, that's how I would frame it. I know I'm not a lawyer though, is that, the justices that are on there, several of them were appointed by presidents that never won the popular vote. So I say that to folks that are very concerned about this, to understand that, we may have lost at the Supreme Court level, but, the hearts and minds of the American public are with us in terms of those of us that believe that decisions regarding a pregnancy need to be left up to that individual pregnant person and their family, in consult with their doctor and within their own faith tradition, but not up to government. And so I want to turn it over to Dr. Ellen Clayton, who can provide some information from her perspective as well.
So I'm going to make 3 points about things we need to do. The first one is that this is a justice issue, this is a freedom issue, it's a liberty issue. We need to claim it. And we need to, we have given away way too much about letting the opponents claim freedom. We need to claim our freedom, our liberty, and we need to be vocal, we need to be out there. The second, actually there are going to be 4 points I make. The second point is that the burden of this is going to fall disproportionately on women and families who are poor and minorities. We cannot forget that. We need to focus on making sure that they have access to the care that they need, not only if they choose to go or if they want to go out of state to have an abortion, but also if they do want to bring the pregnancy to term, we need to make sure that they get access to excellent health care. I mean, the truth of the matter is the death rate among women of color and minorities and poor women is much higher than other parts of the population. We need to double down on making sure that they get high quality access to health care. This is essential. Another point that I want to make is that there was a question made about the issue of about miscarriage, and I'm going to broaden this out a little bit. There is, believe me, there is a lot of reason for healthcare providers to be fearful right now. The stories that we are hearing are absolutely awful. But one of the things I understand about this statute is that a miscarriage is not defined as an abortion under this law. So providing care to women who have miscarriages is something that the law actually permits. Now, I realize that the likelihood that people are going to be called out for this is really, really important. So, but I really want to put it out there. We need to, the healthcare providers need to talk with their lawyers and be sure about what the law permits and what it doesn't permit. And then they need to have the kind of backing in case somebody decides to go after them. I know our DA has said he's not going to prosecute providers here in Davidson County, but the state has already appointed a special prosecutor, to take the place of Glenn Funk. So, I mean, I think we have to think about that. And then I had another point, and I'm going to get to, here is something that women need to know. Do not publish what you're doing about abortion on social media. Do not do that. There was a case yesterday in Nebraska where a woman and her mother posted on social media about doing a late abortion that was illegal in Nebraska at the time. And Facebook, understandably, when they got served with a warrant, handed over the information. Do not do that, okay? And similarly, if you're going to do searches on the internet to look for where you get help, maybe look on the incognito webpage or something like that. But the idea that, we live in a surveillance society. We do, and in an environment where women are going to be punished, for making these kinds of decisions, you have to be smart. And so I'm telling everybody, do not use Facebook. Do not use social media. I mean, just don't. Because if they come with a warrant, they have to answer. So those are my four points. We have to get out there, we have to advocate, we have to claim that this is about liberty. And I will say that what Dobbs really says is the idea, an essential American idea, that you are free to live your life, free from government intrusion. Dobbs set that aside. And that's really important. And so, I bet there's also different privacy protections for data, but those are also limited. I mean, we cannot count on this Supreme Court allowing us to run our lives as we see fit. We cannot count on that. So we have to advocate with the legislature. I have some more kind of medical points to make later, but I want to hand this to Carolyn. Providers, get your lawyers to read the law and give you solid advice. And boy, raise your voice to the legislature.
Thank you so much. And I believe Dr. Looney's in the building, so if she could make her way up here and have a seat up here. I'll introduce Dr. Kim Looney and also Dr. Carolyn Thompson, who will kind of talk about the medical aspects of the latest decision. So Dr. Kim Looney is at Meharry Medical College. She's a Nashville native and an OBGYN whose career is dedicated to women's health, reproductive health, and complex contraception. She was trained at Emory University and has decades of experience teaching medical students and residents over the last 20 years. I'm also really glad to introduce you to Dr. Carolyn Thompson. She's served on Planned Parenthood's board and has been an OBGYN for 25 years and practices here in Nashville as well. And then when we get to the Q&A section of the agenda, I'll invite Dr. Katrina Green. You may see her on social media posts around COVID and things like that, because she has a lot to say about keeping us safe in that regard. But she's an emergency room physician, and we'll invite her up in a little bit to help answer some questions, because hopefully we won't see more folks in the emergency room. But given the latest decision, anything is possible. So let me turn it over to Dr. Looney, and then we'll follow it up with Dr. Thompson.
Good afternoon or evening. I don't know where we are in the day. I don't even know how best to start everything I have to say, because this has been such an emotional topic, I think, for a lot of us, but especially for those of us who were in it. And I am the recently former Chief Medical Officer of Planned Parenthood of Tennessee and North Mississippi. I want to start by giving a couple of stats. And Dr. I apologize. Clayton, thank you, Dr. Clayton. We've met before. I apologize, I'm having brain freeze. But Dr. Clayton touched upon a couple of points that I wanted to make, and I want to start just by giving some stats for us to understand just how big this problem is for us, particularly those on the medical side who care for the women that we all love and are part of our lives. 1 in 700, I'm gonna start with that number. 1 in 700 women in this country die annually from complications of pregnancy. 1 in 700. Match that with 2 to 12 annually from abortion. We lead developing countries in mortality for maternal mortality and morbidity. We lead developing countries in infancy morbidity and mortality. Those numbers are going to go higher because that was in the face of us actually having abortion access. That is now gone away. Also, in 2019, we had an additional 3.3 million people who fell into poverty. That is going to go higher. Part of what drove me to go into family planning, in particularly, my practice is OBGYN, but particularly family planning is my specialty training, was because I learned early in my career that one of the most essential things I could do was to help a woman decide when she was going to be a parent and if that was safe and appropriate for her. I learned that very early. I also learned it's not just a social issue. It is unfortunately politicized, but it is an economic issue as well. It is a death issue as well, and that is what we are now dealing with. I want to speak to specifically a couple of medical questions that have come up. And first, starting with emergency contraception and IUDs. I will state again, as my colleagues have, IUDs are not abortifacients. Abortifacients is anything that I give you. If you're pregnant, you're now no longer pregnant. If you're pregnant and I give you an IUD, you're just pregnant with an IUD. It is not an abortifacient. Now, where does the confusion come from? Because medically, we define a pregnancy is at the point of implantation, not fertilization. Anything that interrupts before implantation is not a recognized pregnancy. Pregnancy is recognized with implantation, which is why, by definition, they are not abortifacient. Nor can I give someone, again, an IUD and cause an abortion. It just doesn't happen that way. Same thing for emergency contraception, which inhibits ovulation. It's important for those of us who believe in a woman's right to choose that we actually understand the medical science and the medical evidence based on how we as physicians practice. And we practice that way because we understand the science. If you don't ovulate, you cannot get pregnant. It's that simple. You need an egg, you need a sperm to have a pregnancy. So I just want to boil that away. Now, in the political climate that we're in, are we in a situation where emergency contraception may be affected? In some settings, yes, because we rely on pharmacies and pharmacists to make the decision about if they make those provisions. Will it go away totally? I don't think so, because you have advocates such as Planned Parenthood who also provide those medications. They can also be gotten in grocery stores and over the counter in that sense. IUDs, because they're provided through your physician's office, I think we should be hopefully safe there, because that's going to be an essential key piece of health care for women now, particularly in states like this, where pregnancy could be a life or death situation for you. So we have to think about having better access, as Dr. Clayton said, to great health care and other parts of our health care. When we talk about medical complications, because there is no exception for maternal life, I do have to say, just as a representative of the medical side, is that outside of this law being just ambiguous in some sense, what it does for me and my medical colleagues, it takes us from the place of being physicians to being lawyers. And I now have to decide, not medically what's standard of care, but first legally what's standard of care, and then what's medical. And again, that may increase your morbidity, your mortality, your life. Because I have to think about, can I continue to practice to help the next person? There are going to be medical situations that become more complicated. We've talked about miscarriage. While this law does not speak to miscarriage, I will say this, every miscarriage is not the same. So there are some miscarriages where they're kind of gray, and there may be a heartbeat, but if she's bleeding and I'm worried about her bleeding impacting her mortality and her morbidity, I now have to decide, how long can I watch her bleed until there's no longer a heartbeat, so that I am legally clear, versus doing what would be standard of care, and that is helping that woman evacuate that pregnancy so that we can decrease her risk. Things such as my water breaks early. 18 weeks is a non-viable pregnancy, but there's a heartbeat. Water's broken, can't touch you. I have to send you home and wait for something more morbid to happen before I can assist you. Things such as IVF. Not all IVF pregnancies result in good pregnancies. Some of them require termination. What happens with those patients who are trying to expand their families? So the extent of what we have done is basically we have changed medicine, not just for OBGYNs, but for all physicians in the state. They're just impacted. So I'll stop there, because I think I'm a little bit in my feelings. I'm gonna pass it over to you.
Well, you're passing it to the wrong person. I'm that way as well. Although I have been aware of all of the things that we have talked about this evening since the decision came down in June, I have to say it is chilling for me to sit here and listen to this so elegantly laid out and so horribly laid out, frankly. In 1991, when I made the decision to be an OBGYN as a third-year medical student, I had no idea that I would be setting myself up to be a criminal. And that's pretty much the way it is now. The American College of OBGYN, which is our governing body as OBGYNs, put out a webinar just a few days after the Dobbs decision came down. And the title of the webinar was Breaking the Law or Breaking the Oath? How Abortion Bans Betray America's Patients and Physicians. And just as there are presidents who take oaths and don't mean them, I'm sure there are people who are physicians who take oaths and don't mean them, but I'm not one of those people. And it's horrifying to me to think that this is what it's come to. And I appreciate Dr. Looney's description of what this looks like on the ground now. Essentially, and one of our OBGYN colleagues said this just a few days ago, the state is basically mandating patient abandonment. It is codifying malpractice. So, as Dr. Looney said, now we have to decide, are we going to do what's acceptable and safe and evidence-based care, or are we gonna do what, no offense, guys, some lawyer tells us that we have to do? I don't tell the lawyers how to practice law. And, you know, I have a skill set that I'm proud of, but you don't want me flying your plane. So we're in an area that is just as dangerous as that. Having politicians tell physicians how to do their job is as dangerous as a gynecologist telling a pilot how to fly 747. When we talk about the statistics, and I appreciate your bringing that up, and just to put a little bit more specificity on that, the way that these statistics are set forth with regard to maternal mortality is the number of women who die per 100,000 births. And the people in the world who do that the best, no surprise, are the Scandinavians. 3 to 4 women per 100,000 die in or around the time of childbirth in the Scandinavian countries. In America, the latest statistics we have are from 2019, it's 27. And if you're a woman of color, multiply by 3. Now we're talking, you know, Moldova, you know, sub-Saharan African countries. That's where we're living from a maternal mortality standpoint. And as Dr. Looney says, it will absolutely get worse. When you think about rights that patients have, or rights that individuals have, if someone is dying and they need a blood transfusion, no one can force you to give your blood. If you've passed away and you have organs that someone else needs, no one can take those organs from you. So basically, corpses now have more rights than pregnant women have. Just think about that. When we get down to the safety of abortion, and so many of these laws that have been passed throughout the country are listed as the Women Protection Act or the Protecting Life Act. When you think about the complications that are involved with abortion, it's safer than having oral surgery done. and it doesn't require as much anesthetic as oral surgery. So all of that is just a red herring to try to distract from what the real purpose is, which is to control women and to keep them in poverty. As physicians now, as we're approaching care for patients who need reproductive care, and more specifically abortion care, as Dr. Clayton said, physicians absolutely need to speak with their liability carriers and to modify their consent process for patients who are pregnant so that they can have some modicum of protection. And like Dr. Looney said, I'm not trained to be a lawyer either, and I don't know the ins and outs of the law, but having that guidance from attorneys who do have your best interest at heart is very important going forward. Communicating with patients with regard to what the laws might be. And I mean, I've already had circumstances where I have to leave the room and say, hey, I've got to call my liability carrier because I need to find out what's acceptable for me to tell you. Going forward, this will have significant impact just with regard to training of physicians and OBGYNs. Now, the way that at least the University of Tennessee residencies work is that physicians in training have to opt out of doing abortion care. So it is a codified part of the residency program, and you have to actively say, I'm not doing that. So there will be fewer people who are trained to manage abortion, and therefore fewer people who are trained to manage miscarriage. And the physicians who are trained will have less experience. And honestly, I don't know what it will look like in Tennessee. They'll probably have to go out of state to get appropriate training. There's also been talk about self-managed abortion. This is an article came out in The Lancet in the UK in February of this year. And basically with about 2,800 patients who did self-managed abortion. So basically they got the pills, they took the pills. There was a better than 96% success rate. And only 1% of patients required any type of treatment for an adverse event, and those primarily included need for a blood transfusion or need for antibiotics. So that is something that is also safe, and we'll see what the legislature does, but I'm not terribly encouraged by what we've seen. And just one more thing I wanted to piggyback on what Dr. Clayton said earlier. I'm encouraging patients to no longer use any type of period tracking app, just because everything's for sale. And if you're tracking your period, somebody online, somebody has access to that. And if the price is right, I'm sure they're willing to turn it over. I better stop.
Thank you so much. Thank you so much. I'm going to ask Dr. Green to come up here, and while she does that, you've inspired me to talk about a few things. I just want to underline for folks, because sometimes it may not be as clear. Like, as of August 25th, every abortion in Tennessee will be illegal. Every single abortion. There are no exceptions. Even Texas has exceptions to their law. We do not have any exceptions. And as Wally and Bill have already talked about, the only way that a physician will be protected is to be able to make some sort of affirmative defense. And those affirmative defenses have to be that this person is a licensed physician, meaning that if you're helping somebody get an abortion and you're not a licensed physician, you do not have an affirmative defense. You're a criminal. You also have to be able to prove that, I can't remember what the second affirmative defense is. We'll let the lawyers talk about that. But there are certain measures that you actually have to prove in order to not be prosecuted. So physicians are on the front line of being at risk of being a criminal. But also anybody that could, I mean, this is a kind of a gray area. We don't typically talk about medicine from a criminal standpoint. But, anybody that helps them, like a nurse or, and insurance companies, if they're covering that, those procedures, like those kinds of things are put people at risk. And so I just wanted to make that really explicit. Right now, it doesn't say that people who are obtaining an abortion are breaking the law. But what we know from other countries is that it's only a matter of time before the criminalization does turn to the pregnant person. Also, you'll notice that we do try to, sometimes we talk about women who are pregnant, and we want to also be trans inclusive, that not everybody who identifies as a woman gets pregnant. And I think that there were some questions online about like, what are the risks to the trans community and how this law impacts us. So that's a question for the future. I just want to put that out there because I think that's an important thing for us to discuss. But we want to take some of your questions. And I don't know if Dr. Green, if you wanted to kind of open with any comments from an emergency physician perspective. So think about your questions and we'll have you stand up and just ask it. Do you have any?
So first off, I just want to say that as an emergency physician, our job is to treat anybody who comes to the ER no matter what. The ER is always open. And President Joe Biden recently emphasized that pregnancy care still falls under EMTALA. So we are mandated by federal law to treat any pregnant person who comes to the emergency department, no matter what the law is in the state. So that's a little bit reassuring. I am concerned that given the state law that's about to happen, that people will be fearful of coming to the emergency department. They might delay care because of worrying about being judged. Women who are having miscarriages might be fearful of, us thinking that they brought that on themselves. And I just want to say, please do not wait to come to the ER if you are bleeding while pregnant, or if you're having pain while pregnant, or any other thing that you're worried about. If you're pregnant and you're having an issue, please come to the ER. Don't wait. The other thing I'd like to mention is that there is no way for an emergency physician, and I assume an OB physician as well, to tell the difference between a miscarriage and a self-induced abortion. So if you do not bring that up to myself or whoever's treating you in the emergency department, we would not know. So maybe don't mention that, okay? While all of us up here would not report someone for self-induced abortion, there are providers out there who would. And we have seen cases where people have been prosecuted because healthcare workers have reported them. And that is heartbreaking to me. And I feel like that goes against not only HIPAA, but our oath to protect the patient in front of us. So just be mindful that a self-induced abortion and a miscarriage look the same to us medically. And so if you want to keep that to yourself, that's fine. We will still treat you the same. One last thing I wanted to mention, Dr. Clayton so eloquently said that now is the time for us to be loud and make our voices heard. It's time to rattle the cages that we're about to be put in as physicians. And so Dr. Amy Gordon-Bono, who is here tonight as well, and myself, we are putting together a rally and a press conference on August 25th, the day that the trigger ban is taking effect. We're going to be meeting at the Justice A.A. Birch building downtown at 11 a.m. There will be multiple physicians and healthcare workers speaking, and we would appreciate the support of other healthcare workers and the community to stand behind us, because we are the ones that are going to be prosecuted And we just would like to know that we have the backing of our community when that happens, so.
Yeah. It's very scary, because if they don't provide care immediately, then they could face criminal charges. And if they do and if they wait, then they could, be sued for malpractice. So it's a really terrible situation for providers to be in right now. Are there any questions from the audience? Hi, Laquita.
Hi, I'm Laquita Martin. Maybe people can hear me. I'm Laquita Martin, and I am the state policy advocate for the National Council of Jewish Women. And so this has been a nail I've been hammering with Francie for many, many years now. My question is, the Jewish faith, abortion is something that is very much supported by our rabbis. And my husband and I had a fetal anomaly years ago, and I had to have an abortion based upon that. The way I was able to make that clear in my head, because I had an IVF pregnancy issue, but my clergy was extremely helpful, extremely supportive, and advised us so intensely, as well as the physicians. And I'm very bothered to think that I have a son who's about to get married, who is marrying a Jewish woman, who is a type 1 diabetic. She could very easily have a pregnancy complication, and it would be in violation of our faith. So I'm just wondering where those of us who have a faith issue, why can we not sue under a violation of our faith? That's a legal question. This keeps coming up again and again. I'm asked that a lot. So I would love.
This has happened in Florida.
Right, I know it's happening, but can it happen in Tennessee? Because we'll sign on. We'll be here.
Well, and I'd like to hear from Bill and others on the panel as well. I'm so glad you asked that question, because to me, if there is a way to attack this statute, that's the way to do it. And I'm not giving advice to you as an individual, I am commenting on the state of the law generally. I'm not advising you to file a lawsuit, but the state of Tennessee has religious liberty protections that exceed what exists under the federal Constitution. The right of an individual to practice his or her religion or their religion is highly protected in Tennessee. So that's a really good question. I think it's one of the few ways this statute could be attacked in the courts. But again, I'm not in a position to give anyone legal advice.
Oh, I'm going to let you take this.
You want me to take it? Laquita, I think it's an unanswered question, and my sense of the current state of the law is that it's not really answered at this point. So, but, we do have cases, even in this current Supreme Court term, that lift up the free exercise of religion above lots of other things. We have a case that permits a coach to pray on the 50-yard line, because that's his belief that he needs to do that to practice his religion. And I'm confident that under prior Supreme Court precedent, with different makeup of the court, that wouldn't have been decided that way. But perhaps that is, things ebb and flow in the way people view the Constitution. And perhaps that might be an unintended consequence of what they've done with the high school coach, that emphasizes the religious liberty aspect that perhaps could be of some help. I mean, I don't know for sure, but I think I'm lacking confidence in courts right now to do what I'd like to see them do, but it's an avenue, perhaps.
I saw a hand back there. Hi, striped shirt.
Hi, you mentioned that ordering abortion pills is illegal, so I'm wondering what is the criminal charge for ordering them? And then if you use them, are you facing that same criminal abortion charge that a physician would face?
In Tennessee, a person needs to leave the state to get a prescription for the abortion pill and complete the entire regimen of that dosage in another state where it is legal. Otherwise, that person, if they come back to Tennessee with the pills and use them here, they are technically violating state law.
Follow up on that, would you recommend that the abortion itself take place out of state, or would it be legal to travel, like, up and then come back?
Where we are right now in Tennessee, it is not against the law for a person to go to Illinois or another state where abortion is legal, obtain an abortion there, and then return to Tennessee. That is not illegal. It's not illegal to cross state lines to go there. Bills raise the possibility, and others have commented that the legislature in Tennessee or other places may try to criminalize that act or at least make it unlawful. But today in Tennessee, and until the legislature changes the law, a person in Tennessee can travel across state lines to a state where abortion is legal and obtain an abortion there.
Yeah, I think it's important, like, to realize that for many years, not even abortion-related, telemedicine for abortion has been for a number of years illegal here in the state of Tennessee. And while it's still legal to tell people information, I'll tell you this, the National Right to Life has had some model legislation where they want to prohibit people from crossing state lines. They want to prohibit people from being able to tell people where they can go get help. They want to create like those aid and abet laws, like what Texas has done. So now while it's legal, like, I can probably tell you safely that there are websites out there. There are plancpills.org, there's abortionfinder.org, there's reproresource.org, and there's I Need an A. .org, and those plancpills.org is a place where people could, and I'm not saying to do this, I'm just giving you information that this exists in the world, that people could go to those websites and get pills. The World Health Organization has identified self-managed abortion as a safe procedure, and it's been interesting to kind of contrast the United States to the Mexican movement, where in Mexico they focused on access, whereas in the United States we focused on the right, which I don't think we're wrong in doing that, because we should have a bodily autonomy right. But other areas have focused on access. So like, you could literally go to Mexico for fall break, for example, and walk into a pharmacy and get misoprostol for $40, and that would be something that you could get there. It's also interesting to note that, you know, with mail, like, you know, like first-class mail, that is something that can't be searchable. I've heard. Again, I'm just telling you this just for your own knowledge. I'm not recommending that anybody do that at all, because we always want to, you know, follow the law. But those are things that I think people are talking about and, you know, ought to be aware of.
So Francie, before you call on the next person, would you please talk about what Planned Parenthood is doing with the patient navigators and providing, I mean, people need to know where they can turn to get help.
Yeah.
To go out of state. So would you please say that?
Yeah, absolutely. So within Planned Parenthood, we have a navigation program where we have someone who will help shepherd somebody to care out of state. There are some facilities right now that are providing medication abortion up to that 6-week mark. We decided not to, because we wanted to be able to get them to care as soon as possible, because we were worried. Remember, in Tennessee, we have a 48-hour waiting period, so it takes some time. So we were a little concerned that by the time they got to us for the first visit, then it'd be hard to be able to fully help provide care by their second visit. So we're just helping people get access to care outside of state as soon as possible. That means we're willing to help provide funds as needed, helping make sure that people get transportation as needed if they need accommodations or childcare. We're helping, like, as social workers, helping them navigate that. It's important also to mention there are also abortion funds that I tell that to you as folks that may want to give, or people who may need to access abortion funds for their own use. There's Mountain Access Brigade. There's ARC here in Middle Tennessee, and then Sister Reach in Memphis is an entity that also provides abortion funds for folks that are in need. Any other questions? Hi, in the front, and then I see you, Whitney.
And then Ms. Sweeney mentioned that how the heartbeat plays into like whether or not it's considered an abortion or not. So I wonder if you could clarify anything on that.
State law right now, where a district attorney in Nashville, Glenn Funk, declares that he will not enforce a law at all. The state now can bring in a special prosecutor to prosecute a crime that the DA here is refusing to enforce. That is currently the law. And I may have missed the second part. I'm not sure it was directed to the lawyers.
But it hasn't
But,
happened.
yeah.
No special prosecutor yet.
So I'll try to answer your question without confusing you a little bit more, but I need to do that by starting, excuse me, because I've got something in my throat. I need to do that by starting with the actual medical definition. Miscarriage, induced abortion, to doctors all the same. They're all abortions, okay? When I code it, when I put in my medical billing coding, abortion, 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 abortion. The word abortion in medicine just means the end of a pregnancy. It doesn't suggest how that pregnancy came to an end. So when we're managing miscarriages in the hospital with a heartbeat, a lot of the times how it's managed really depends on your hospital system. Prior to this bill I'm talking, it depended on your hospital system, and I'll give you an example. I trained, like most residents train, where you have a university hospital and then you may have a community hospital, which more often than not are religiously affiliated. If the same person walked into the university hospital and she had a non-viable pregnancy, meaning anything less than 24 weeks, whether there was a heartbeat there or not, I could always counsel her for the option of assisting with completing the pregnancy. If she walked into the same same patient, different location, then for that particular patient, I would have to counsel her, I cannot assist you until there's no longer a heartbeat. And when there's no longer a heartbeat, hopefully nothing bad has happened to you, you can come back and then we can assist you. Or things have to be progressing so that, you know, you're going to be impacted by whatever's happening, infection, heavy bleeding, what have you. That is now the situation I think most of us will have to practice in, regardless of what your hospital system is. There are what we call ethics review boards that when you have questionable pregnancies about whether you can assist with completing the pregnancy or not, you could have sent those cases to the ethics review board and they make a decision based on a consensus of physician opinion about if you could proceed with that pregnancy. I'm not really sure if those boards are gonna have any type of tooth with this particular law in place, because it kind of takes the power away from even that, where at least even if I was in a religiously affiliated hospital, I could say, this patient needs help. I need you to consider all of the medical implications of us letting her continue to be pregnant. So I don't even know if I answered your question, but it will come down to there will not need to be a heartbeat there before we could assist a patient. Because again, even if we assist her with a heartbeat, we're putting ourselves in legal jeopardy.
There's so much confusion about that, and so, you know, just underlining, we even hear the people who are bill sponsors of the trigger law miscommunicating what the bill actually means, and I don't even, like hearing them talk about it, I actually think they believe what they're saying, but when you look at the law, it's actually, they'll say, like, don't worry, there's exceptions for the life of the mother. That is not in the bill or in the law at all, so that's really important to realize. I think somebody had their hand, but Whitney.
Yeah, my name's Whitney Anderson. I've been an escort at Planned Parenthood for years, and I'm really concerned when this trigger law takes effect, how is that gonna affect me? I mean, am I a criminal, and, you know, am I in danger if I continue to help patients?
Oh, I don't really have the answer.
You know, I think those issues are unclear. I mean, if helping a woman means that you're aiding and abetting, if Tennessee passes a law that specifically calls out everybody who aids and abets, so it would affect you, it would affect employers, it would affect all kinds of people. I think that you know, these are times when, where things are vague, and when they're vague, that means they're dangerous.
And for those who haven't been obsessing over abortion rights over the last couple years, you know, when we talk about aid and abet, it's kind of modeled, it was this, I would say, somewhat of a fluke of legislation that actually passed in Texas last fall that said that anybody that aids and abets could be sued by some random private citizen. And so that put it in a different legal category than what we're traditionally, you know, used to, where it becomes like a issue of governance. This was more around like an individual's right of private action. And so that's something that hasn't been tested really constitutionally at the Supreme Court level, and it's been not argued yet. It's just been upheld and allowed to happen. And so that's the danger, is that just because something's not constitutional doesn't mean you won't get prosecuted. So that's where that gray area comes in. And I don't mean to scare anybody. I just want you to be open-eyed when you're brave and bold to help people. Oh gosh, I think Emmy, it was you, and then you, and then you.
Well, just to Dr. Looney's example, so in 2009, I was pregnant 7 weeks. I started bleeding. Turns out I had walking pneumonia. I walk into Vanderbilt ED, and I'm in terrible pain. I'm bleeding, and I say to the physician who is attending to me, "Clearly this pregnancy is not viable. Please terminate it. I am in terrible pain." She said, "There is still a heartbeat. I cannot do anything to this." So this has been happening already to some extent. I went septic. I almost died. I was in the ICU. I'm grateful to be alive for the care that I got. But the fact is that people, you know, there are people saying women aren't going to die. They weren't like, you know, women were dying from self-induced abortions before. Women are going to die on some level, no matter what. And it's maddening to me. I have a 14-year-old, and I'm like, so if she were to get sexually assaulted and be pregnant, and she had a life-threatening condition, they would not save a child's life in order for her not to have an abortion. That is the most maddening.
So
it's scary.
I want to say something about conscientious objection. Ever since Roe was passed, almost right away, the feds passed a law that said that anybody involved in medical care can refuse to participate in abortion without consequence. And so I think one of the things that we see, there's a wonderful, wonderful article in New England Journal called "The Celestial Fire of Conscience" that I think is available in front of the paywall. But in any event, what we see is that people who decide for a variety of religious reasons not to provide end-of-life care, not to provide contraception, not to provide abortion, they get a free pass in our legal system. And what we see here is that for clinicians who want to take care of patients, who want to follow their oath, who want to do the right thing, they are subject to criminal prosecution. So I just want to be clear here that there is a wild asymmetry. So I hope you know that Vanderbilt, at least until now, has traditionally, you know, been very pro-women and pro-choice. But but what you ran into was a doc who didn't want to help you and didn't have to pay for the consequences.
If I could just add something briefly, these last couple of questions and comments prompt me to say something I've wanted to say for a while tonight. I have friends, I know many people who have a sincerely held belief about when life begins, whether immediately a conception or later on during the term of the pregnancy, and they would support legislation similar to this. But even those people, and I think, frankly, many of the legislators who take that position would be surprised by how dangerous this bill is. by the ambiguities in the bill, whether or not conduct is criminal or not, whether or not medical professionals are going to be able to save the life of their patient. Those things are very real. And I would encourage you to speak to your legislators, encourage your families and friends, especially those who live outside of Nashville, around Tennessee, to talk to these people, because I don't believe they fully understand just what a nightmare this bill is going to cause in Tennessee in 2 weeks. And I'm coloring outside my lines, and TJ's going to call me down, so I'm going to quit talking.
So we're nearing our time at the end, so I want to honor our time, but if the doctor wants to speak, and then I saw the person in the back, we'll take those two and then we'll end. Does that sound good?
Good evening. I'm Rich Orland. I'm a physician. I'm a primary care internist. I've been here in Nashville now 44 years. I came to Vanderbilt to do my residency. I'm a primary care internist. I've been in all sorts of patient situations, and one of the most important things that needs to be stated explicitly is the bond between a physician and a patient should be inviolate. Inviolate, whatever the term is. It's almost sacred. So for a legislator or a legislature to become between this is horrendous. It's breaking a sacred oath. And I've been so privileged, because if you come into my office as a quote patient, you don't know me from Adam. You don't know if I fake my certificates. You don't know if I fake my license. If I'm just someone off the street that says, hey, welcome, I'm a doctor. How can I help you do that? So the fact that legislators are violating almost a sacred oath really ticks me off. The other thing is that we need to realize that, as you were saying, we need to speak out. And my motto is, be loud, be proud. Because what I've seen is that I've seen so many things saying, quote, believe and belong to organized medicine. Organized medicine is the only way we'll have our voice. Locally here, it's the Nashville Academy of Medicine, it's the Tennessee Medical Association. And their focus has been on practice of medicine in terms of the scope of the license and other things in terms of who's approved to do what. This issue has never been undertaken by, quote, organized
That's right.
medicine.
I'm sorry.
Never. And I'm very interested, and I'll say it now, and I'll say it in other forums, I'm very interested in forming a subset of physicians like ourselves here who can come together and work as a very active, very loud subset to change the TMA stance. Another thing, there's something known as the corporate practice of medicine, which I believe is against the law. I submit that the legislature is practicing medicine without a license. The legislature is practicing medicine without a license. One more thing, my wife and I went through this horrendous experience, possibly the most soul-breaking, heartbreaking experience we went through. At 19 weeks, what was supposed to be a routine ultrasound showed multiple heart defects. We went to a second appointment with a different neonatal cardiologist. Things were even worse. We had 4 options. All of those 4 options led to the gates of hell. We chose, ultimately, the least painful operation for our unborn child. Essentially, we suffered, so our child wouldn't. We consulted with multiple physicians, unhome physicians throughout the country. We talked to physicians here, pediatricians for our son. we talked to a very knowledgeable pediatric cardiologist as a friend who gave us tremendously good advice. Yeah. We also talked to our legislature, so religious leaders, friends, and knowledgeable physicians. Not once did we talk to a legislator.
That's right. That's right, that's right. Thank you so much for sharing that story. You've inspired, all the doctors in the room were like, ooh, we like what you're saying. Last question, I'm sorry, I know there's so many more, but I know that we said we were gonna end at 7:30, so I wanna try to keep to as close as possible. But I think it'd be okay if we, said stick around if you have questions. We've got our panelists that are gonna be here. You can get your questions answered, but I promised you all that you'd be able to ask, so go ahead.
I just wanted to circle back to Striped Shirt's question. Wally, you did a great job of reiterating what the law states as far as if somebody from Tennessee were to obtain pills to abort their pregnancy, is there a chance we can catch a charge? That was the final portion of Striped Shirt's question, so I wanted to know what the answer to that part is. Thank you.
I can only advise what the law is. I cannot provide a risk analysis, which is essentially what you're asking for. I'm sorry, I'm just not in a position to do that.
So is that because there hasn't been something that's happened yet where somebody's been charged? Like, is this, I guess what I'm trying to figure out, is this a wait and see kind of process?
Yes.
Look, I think the point's been made. The law is so vague, it's hard to know. And we don't know whether a special prosecutor, for example, would get appointed here in Nashville. There's a lot of questions about what prosecutors choose to do or not do. So when you say, can you catch a charge? The answer is maybe, but we just don't know. Sorry.
Yeah, like if it's a self-managed abortion, are you considered the physician, and is that then a Class C felony? But that's different than telemedicine, so, yeah, sorry. Yeah.
So I said I didn't want to be an attorney, but now I might be trying to do that. It seems to me that the way the legislation reads is that you have to be a licensed physician in order to do this. So any individual person, it seems they would be open to liability if they did this on themselves.
You mean that the affirmative defense is for a licensed physician?
Yeah. So that's the extent of my legal opinion.
Yeah. I'm gonna end this just because I know some people might have expected to leave at 7:30, but that doesn't mean I'm kicking you out. Stick around, ask your questions. Thank you all so much for being here. I mean, obviously, there's a lot to cover. We're in a gray space. I do want to encourage you to please, if you haven't already signed up to come today through our sign-in link, go to tnadvocatesforpp.org. That's Tennessee Advocates for Planned Parenthood. I'm the executive director. There's lots to do to help make the world a better place through our advocacy and organizing. We have a grassroots organizing retreat happening August the 19th through the 21st. We have lots of ways that you can get the training that you need to help organize power in this community. So thank you all so much for coming.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.